follow Rule 6 all through, you read the control rules, you read the directives. That is meant for unopposed motion, which used to be 12 o'clock Thursday for the following Tuesday. If you want to do it not in terms of that, you follow 612, which is the urgent matter. You do not simply enroll a matter that should be on the unopposed roll in the urgent form, unless urgency exists. There's no urgency of existence. The belief that you are seeking is, as far as I can make out, deals with issues of constitutional nature. Now, have you followed the procedure? I think it's Rule 16, which procedure should be followed if you want to argue a constitutional point. But the whole tenet of this application is not on an urgent basis. And then you bring it ex parte. You get served on the other party, but is either served on the other party in a normal manner, giving them the necessary time. Ex parte is when you seek relief urgently or whatever way, and you seek a relief. None of that. This application is simply not on, should not be on this road. You should approach the registrar dealing with unopposed motion to enroll it. If you say it's unopposed, it's such extreme short notice given to government parties. The attorney, the president, Minister of Defense, and the Chief of the those are the three main defendants or respondents. And did you ever serve on Michelle?
Correct, Your Worship.
When and how?
Via email, my lord.
Yeah, but is that allowed? What is Rule 4 say?
My lord, if I may, the matter responds to a matter in terms of Rule 612. And it is brought in terms of Rule 6.4, having understand the parties there. The parties primarily, the relief sought is mainly from the first defendant. The second defendant is only called in terms of Section 83 of the Constitution as the head of the state and the head of the national executive, who must uphold, defend, and respect the Constitution as the supreme law and promote the unity of the nation.
What was the
The issue here is the statute and its integrity. And the supremacy of the Constitution and the rule of law.
How can you get that against the attorney? What must they do?
It is, if His Lordship understood the draft order on record and the relief sought there, it talks directly to the two matters. And one, this particular matter, it seeks to have the first defendant to desist from obstructing or interfering with the defense force in the execution of its duties in accordance with the Defense Act or the Constitution, as envisaged in terms of Section 104.10 of the Defense Act 2002, and also seeks to have the first defendant desist from inducing or attempting to induce a member of a defense force into neglect or to act in conflict with his duty to the defense force, as envisaged in terms of Section 104.10.11 of the Defense Act. And also, the first defendant has stifled with the grievance procedure and contravening the applicable terms of Section 17.
All this you want to have obtain an order from the court ex parte, which means without notice.
My Lord, the rules have been explicitly explained in the second paragraph in the founding affidavit as to how does it apply to this particular matter. And one has confined himself strictly to the applicable terms of the rules and then followed them to the letter. As integrity has been explained in this founding affidavit to be that of a person having to play by the rules and play to win. The issue that is at stake here is the freedom of conscience, religious belief, opinion, or thought.
Are you a party to those proceedings?
Yes, my Lord. I have brought the proceedings to the record of court after they could not be brought to the record of court for 25 years. And I did not go.
No, exactly, sir.
Yes.
Why is it now, after 25 years, why is
That the issue of the nature of the proceedings, if I may address the court in that, are in terms of the constitution of the International Pentecostal Holiness Church. That particular constitution constitutes its members to follow a David star, a six-pointed star that must be led by the biological son or by the biological grandson of the founder and comforter of the International Pentecostal Holiness Church. And the reality that has been in the record of court is such that such a state has been stolen by the people that are not the biological sons or the biological grandsons of the founder and comforter of the International Pentecostal Holiness Church, Frederick Samuel Modise. Frederick Samuel Modise only had one son, which is Nchimane Simon Modise, who was obstructed or interfered with by Leighton Modise, who took his heirship as the person who is a successor in that particular church. Now here, the trick of the matter is that the matter was entrusted to the defense force, as explicitly set out at Section 200 of the Constitution. Its primary object is to defend and protect the Republic. The Republic includes the people of the church, not only a class that came to me and then was made not to believe the applicable terms of how to enforce their fundamental right. And the court is called as per its oath in that particular matter.
Yes, I'm asking you questions about urgency.
Yes.
Whether you're in the correct court. I didn't ask you to argue the matter.
Yes.
You're arguing the matter.
I'm trying not to, my Lord. I'm just only trying to give...
No, but it's very simple. You say this has been going on for 25 years. Now it's 30. Although you say it's not urgent, now all of a sudden 30.
The issue, the problem here is the promotion of the spirit, purport, and the objects in the Bill of Rights, as I am obligated to only act or am taught to act.
You must understand the proceedings in this.
If
this is not this court, this application is not meant for this court.
My Lord, if the court sees the application not fit to be heard by it only...
I will strike it off the roll, and you can follow the normal course in applying for a place in the unopposed roll.
The issue is the authority of the defendants and their applicable nature in the Constitution, my Lord. That is why this matter has been brought ex parte. And as it is on record, it is not opposed, because what the President, what is being called for, is exactly his mandate in accordance with the Constitution. He cannot...
No, I understand that.
Yeah.
I understand that. This is not the court to argue. Simple.
If
You have applied the rules incorrectly related to the application. this nature, if it's an ex parte application, which cannot be. There should be proper notice given to all the respondents, defendants in this matter, has not properly been done, and evidence is done in an inappropriate manner, such ultimate short period, nothing can
My Lord,
come from it.
if I may, with humble submission that in terms of paragraph 2 at page 022 on record, I said for the Honorable Court to enroll this application dispensing with the forms and services provided for in terms of Rule 6.4 of the Uniform Rules of Court, in compliance with the applicable terms of Rule 6.4a, the undersigned brings an ex parte application by way of notice to the registrar supported by this affidavit and files it before noon on the court day, but one day preceding the day upon which it is to be heard.
Yes, and I'll
And
explain to you that that rule means it is 12 o'clock for Tuesday. If it is for Monday, it is 12 o'clock Wednesday.
my Lord,
That's how it applies in this decision, this provision for since it's been created.
my Lord, it is an issue where one follows His Lordship, the Honorable Sutherland J's view at in the matter of Alde versus the Minister of Home Affairs at paragraph 40 there in that judgment where he says counsel really needs to research and apply the law and present the honest account of such research. And here, what one did has only researched that applicable rule. That is why I've seen it to
But
be...
I'll explain to you now that you do not interpret that rule correctly. This matter is to be heard in the normal court, not on Thursday. Not one submission has been made why this is so ultimately urgent that I must strike all those laws and statutes.
The thing that was made that makes this particular matter urgent is the law of the land, which I have said
Yes,
on
I've
the
heard
notice
that
of
submission.
yes,
And I've
and
indicated to you that that is not urgent as is intended for this court to hear.
my Lord, please, I beg His Lordship, please.
I'm not going to entertain this.
It's not an issue of His
I'm
Lordship.
going to strike it off for what was there,
His
and I will direct that it be enrolled in the appropriate forum in the appropriate manner.
and such advice and such order will be obliged with,
Yes.
diligently so. I am not in dispute with that. I'm just only wanting His Lordship to follow the library that has brought the application in its applicable terms. And I understand His Lordship's view and status saying that this particular application on its own does not address agency. And then it could not when one follows the applicable terms of Rule 6.4.
Yes,
Because
because
unlike,
I have that submission.
yes,
But
and
I've already explained to you why that submission cannot stand.
fair
You
enough.
do not repeat that I have your submission for that.
Correct, my Lord. And that is an issue where now, relative to the agency of having to apply or enforce the right in the Bill of Rights, such agency is in terms of Section 237 of the Constitution. And the court would understand its independence and its subjectivity only to the Constitution. And I fail to excite my library with saying that the court does not want to take the submissions that are on the papers as they are, because here, the issue here, one has said it on the notice of set down and explicitly set it out that since the locus standi at paragraph 1 of this particular matter, and it is not me, it is not how an issue is, it's just only statute. It says, since the Constitution of the Republic of South Africa, Act 108 of 1996, is the supreme law of the Republic, and any law or conduct that is inconsistent with it is invalid, and the obligations imposed by it must be fulfilled, and that all constitutional obligations must be performed diligently and without delay. Striking this matter from the roll, dismissing it or ordering it not urgent simply means that reason for law at Section 2 and Section 237 of the Constitution ceases. It further says, "Cessante ratione legis cessat ipsa lex." When the reason for a law ceases, so does the law itself. In Herbert Broom's text of 1858 on legal maxims lists the phrase under the heading Rules of Logic, stating, "Reason is the soul of the law, and when the reason of any particular law ceases, so does the law itself." And further said, the first defendant is called for law or conduct to be set aside by the Honorable Court as it is inconsistent with the obligations imposed at Section 237 of the Constitution, delaying diligent performance of all constitutional obligations. These are the founding terms of this matter, my Lord. It's not an issue where this particular matter is founded based on the supremacy of the rules over the supremacy of the Constitution and the rule of law. Hence, that is why on the notice of set down, it was said that on Thursday, the 13th day of July 2023, the Honorable Justice Mokhaba struck the matter from the roll, having inter alia read the first paragraph of the founding affidavit in the terms that I have advanced. And I am asking this court to only subject itself to the Constitution when dealing with this matter, because this matter is indeed the res publica. And in the in terms of Section 16 of the Constitution, the media is briefed, I am having a problem of judicial officers not wanting to fulfill the supremacy of the rule of law. That is the problem. And in any event has always been the problem, with the hidden issue of bringing the rules, which are in terms of Section 172 of the Constitution, that are in direct contrary to the applicable terms of the Constitution. I understand how many people have tried to avoid bringing justice to my life. I understand what had happened. But the Constitution is indeed, my Lord, the supreme law of the land. And His Lordship would understand it to be clear that Article 6 of the Judicial Code of Conduct as the prevailing standard judicial conduct, which judges must adhere to, obligates a judge to at all times, also in relation to extrajudicial conduct, comply with the law of the land, obligating that this Constitution is the supreme law. It is paragraph 4 of the notice of set down, my Lord. I am not out of the context of the paper that is before the record of court, failing to only follow logic that is not confined in the four corners of this particular matter. This matter is exactly what it is. And it sought for the court to bring an end to an illusion that let it be true that never and never again shall it be that this beautiful land will again experience the oppression of one by another and suffer the indignity of being a skunk of the world, and make the draft order on record an order of court. Because I, personally, as counsel bringing this matter and the plaintiff on the matter, suffer irreparable harm each and every day, where my inalienable right for life entrusted to the nation and the state is impugned upon by law or conduct that is inconsistent with the applicable terms of the Constitution. And one would understand that in the DOD personal system, the system that pays my salary, since 8 August 2018 has been told that I am convicted in terms of Section 105 of the Defense Act, while the reality is that I am not convicted in terms of Section 105 of the Defense Act. And I am forced not to desert my duties because in terms of Section 64 of the Defense Act, my discipline is subject to the Code of Military Discipline. Once I desert my duty, I invite a sentence of 20 years while in active service, and while not in active service, I invite a sentence of 10 years. Because what I hold on my shoulders, my Lord, is South Africa. On my rank, it's written South Africa. How do I know what is South Africa? I go to chapter 1, section 1 of the Supreme Law, and then I find what South Africa is. And that rank, it's a permanent commission that cannot be undermined by any person referring to the plaintiff as a mister on court record, because it will be unjust for any person to refer to his lordship as mister on court record. It is not a decorum of the court, and it is not practice that must be condoned.
Now the merits. I've gone through your counting episode,
As it pleases the
court. And I did not invite you to argue the merits. It's as simple as that. You were to address me on two issues, which
The agents.
is one wrong.
My apologies, my lord.
We are now in lunchtime. 2 o'clock, there are other people coming. This court can't entertain vagueness, etc.
And I'm
It's
indebted
not
to the
that it's
court.
not.
My lord, as the court
It's for
pleases.
me, in my discretion, to consider whether the question is right or not.
Correct, my lord.
Yes.
And I am forced anyway to oblige with the court order as it will be in terms of section 165(5) of the Constitution. And then I just only ask His Lordship to direct the matter such that it comes to an end. And to...
I can't do that. I can't do that. I can only deal with what is before me. What is before me? Is this an urgent application? Is it properly before me? If it is not, that's the end of it. I can't bind any further court down the line as to what they should do.
My lord, however, that would be undermining my library in terms of section 172 of the Constitution.
No, I know how that works.
Yes.
You read certain sections out of context.
I don't.
You read everything together.
My lord,
That is not how
the
it works.
Constitution has got 243 sections.
Yes.
Yes. And
But
I
this is
understand
also-
all those particular sections, for I protect them with my life.
Yes.
It is my manual. The Constitution is my manual.
You
When His
made a
Lordship...
submission, are you done?
No, my lord, I ask the court to be, in terms of section 165(2) of the Constitution, subject only to the Constitution. The Constitution first, before we jump to the rules, before 165(2) of the Constitution, which reads verbatimly, the court is independent and subject only to the Constitution and the law, which it must apply impartially without fear. Fear is an acronym of false evidence appearing real, and favor or prejudice. And I submit that the plaintiff is prejudiced by this law not being upheld, not being defended, and being respected as the supreme. Yes, yes. And I ask, the new submission, my lord, would be in terms...
Issues that you should address.
The new...
Not on the merits.
Yes, the new submission, my lord, is just only that. I can only tell this particular court the applicable terms of the Constitution, for I am subject to the Constitution as obligated in terms of section 1995 of the Constitution, read with section 14I of the Defense Act, which obligates me to act and requires me to act, and I am taught to
But
act.
you are not being stopped from acting in that matter. It's
But-
just in another court. This court will not and cannot.
Yes,
You
and
understand?
and yes, that is why
And if
I'm...
you accept that, then
Yes,
then-
and
then
I
you will appeal the order and-
I accept that, my lord. I was just only appealing to this court to take into account the urgency of the matter and direct it to a court that can hear it in accordance with its applicable terms only, my lord, as it pleases the court.
matter B 3506/2023, the applicant applied for certain relief which deals in effect with constitutional issues and the like. There has been non-compliance with the rule relating to matters where a constitutional issue is to be decided by a court. Furthermore, the matter is brought in terms of the provisions of Rule 6, sub 4 of the Uniform Rules of Court. Those provisions rely where matters are unopposed, and in particular where ex parte applications are brought, it is dealt with in terms of that subsection of Rule 6. That deals with the issue of unopposed motion and the directives and rules in that respect, providing for how those matters are to be brought before court and enrolled. The following paragraph, B, deals with the setting aside of law or conduct. A declaration in terms of section 199 sub 5 of the Constitution is sought. The rest of the relief that is sought is either constitutional or to an extent in respect of personal issues that has been raised. In the counting affidavit, no submission contains why this matter is urgent, and to be so urgent that it is enrolled on the role of the urgent force on an extreme urgent basis. The submission made by the applicant from the bar to the effect that where the Constitution applies, everything is urgent, and the courts must just follow suit. This is not an application that qualifies to be brought in application ex parte. There are allegations that it was served on the various respondents, defendants and cited in the heading of the notice of motion. No time limit has been offered to any of these defendants as to when they should oppose and when they should file those in favour. It being an ex parte matter, those parties would expect in the normal course to receive an order indicating a date, a return date, when they should deal with the application. None of that is contract.
My Lord, if I may, it is on the notice of motion, just underneath its further notices, my Lord. If I may give His Lordship...
I have it.
Let
I'm
me...
busy with the judgment.
I'm just only making sure that the court does not make a mistake, my Lord, and make a wrong judgment. Take further notice that any person having an interest which may be affected by a decision on an application, as it pleases the court.
No time period was set when the defendant should give an indication as to when they should oppose and when they should file the case. The rules are clear as to what is to be set out to normal application, and where there is an ex parte application, one would have expected some trade indicating a rule need to be issued with the return date and to be served. None of that has been complied with. In short, this application is enrolled in the urgent court without compliance with any of the provisions and procedures prescribed for matters of to be heard as urgency, and furthermore, the reliance on Rule 6 sub 4 is erroneous and of no consequence. I accordingly grant the following orders. 1. Dismiss the instruct from the roll. 4. A. Want of urgency. B. Want of proper enrollment. C. Non-compliance with the provisions relating to constitutional issues. The applicant is directed to approach the relevant registrar dealing with the enrollment of applications in the normal course of the day.
As it pleases the court, my lord.
Court will adjourn.
Hey, are we done?